Morning, everyone. We'll just wait because I know we've got a few more that's due to join, so we'll just give it a couple of minutes, see if anyone else does join. Morning, everyone. We'll just give it a couple more minutes. I think there's quite a few that's still yet to join, and then we'll get started. Right, well, we'll get started because it seems that everyone who's joining is probably here now. So, good morning, everyone. I'm Hayley, a solicitor at Forbes Solicitors. Before we do start, I just want to say that the webinar is being recorded, and after the webinar, everyone will receive a copy of the slides that I'm going to go through. The recording of the webinar will also be available to access on YouTube after after it's finished. If anyone does have any questions throughout the webinar, if you put them in the Q&A box, and I'll try to deal with them at the end for you. So by way of introduction, as I say, I'm Hayley Wharton. This webinar will equip you with the knowledge and resources to effectively deal with a situation where you might be faced with where items have been left in the communal area, either by the tenant, and not making sure that you follow through the procedure lawfully when we're looking at disposing of those goods that have been left. So just need to bring your attention to the note. These materials are supplied as general illustrations of legal issues and are not a legal advice applicable to any particular person or situation. These materials may not be relied upon as legal advice. Forbes shall not be liable for any loss caused to any person through any action or omission made in reliance to these materials or any connected presentation. So without further ado, I thought what we'd do is, before I go into the depths of what steps we would take when we're faced with a situation where items have been left in the communal area, I thought I'd start by looking at what is meant by an involuntary bailee. So an involuntary bailee is someone that finds themselves in possession of goods without consenting to it. So generally, the tenancy agreement will often expressly state the tenant's obligation to not leave items in the communal area. It's also common for the tenancy agreement to clarify what the landlord can do with any belongings that may be left. In the absence of any express term in the tenancy agreement, any goods left remain the tenant's personal property, but the landlord will become what is referred to as an involuntary bailee. So an involuntary bailee has a number of duties that they must not deliberately or recklessly damage or destroy the goods, and must take care, if trying to return the goods to the owner through a third party, to confirm that that third party has the owner's authority to receive them. We'll come on to that in a bit more detail later in the webinar. But when you are faced with a situation where items have been left in the communal area, the starting position is to make inquiries with the neighbours to see if they know who has left those items, if we are unsure. Following on from that, once we've made those inquiries, we then look at carrying out an inspection of the communal area and make a detailed inventory of the goods that have been left there. So what we'd always recommend is that you take photographs of the goods that are present and focus on any pre-existing damage which is identified. Special attention should be paid to valuable items such as jewelry or any antiques. Although it's not a legal requirement, it will safeguard your position if the tenant or a relative subsequently tries to claim allegedly that a valuable item has been disposed of. So ideally, two people should inspect those goods and compile the inventory so as to minimize the ability of the tenant to dispute the extent of the items left. It may be a possibility that if you are able to, you may wish to remove the goods to place them in storage. The goods do not have to be kept in the communal area. So there may well be a cost element in doing this. So it will just need to be factored into your decision making as to whether or not you'd want to do that. In terms of what steps then you would take when dealing with those items, you need to check your policy and the tenancy agreement for any clause which determines how you are required to deal with the tenant's goods that have been left in the communal area. This may include how long you're required to keep them and the way in which you must deal with them depending upon the circumstances of the case. So, for example, that you can sell them or dispose of them after a certain period of time. Consideration should also be given to any internal policies that may exist, and you must make sure that you follow any set procedures that are laid out within your policies. When it comes to once you've done all those steps, the next step would be to prepare and serve a collection of goods notice pursuant to Section 12(2) and Part 1 of Schedule 1 to the Torts Interference with Goods Act 1977. So this will require the tenant or the true owner of the goods to come and collect the items. We'd serve this notice. Basically, there's two advantages to this, the reasons why we'd serve it. One being that the notice is the first step in the process, which will ultimately entitle you to sell the goods that are left. And secondly, it may help you to establish that the items have been legally abandoned so that you may then be free to dispose of them. This will be beneficial if it is to determine that the cost of selling or storing the goods outweighs the value of those items that have been left. So I thought what we'd do is we'd have a look firstly at the actual act itself, which clearly sets out that what should be contained within this collection of goods notice. And it says that it must specify the name and address of the bailee, being i.e. the landlord. It must give sufficient particulars of the goods. So it must itemize what goods have been left. It must give the address and place where the goods are being held, that's if they are being held in storage, and state that the goods are ready for delivery to the bailor, which is the tenant. So that notice can either be personally delivered, left at the last known address, or sent by post to the last known address. If the owner is not known, and we've done all the investigations to try and find the true owner, and we can't locate them, then a copy of that notice should ideally be placed on the items and be visible to anybody walking past that would see. Once that collection of goods notice has expired, you've then faced with two options. So which will largely depend upon whether or not the goods are of any value and or whether or not they are in a saleable condition. So if the goods are of little value, you may wish to just dispose of them on the basis that they've been abandoned and not been collected after you followed through with the collection of goods notice. There remains a risk in doing this, however. The question of whether the goods have been abandoned can never be guaranteed, and it falls to be determined by the court. There's a saying that someone's trash can be another person's treasure. So if the tenant does return, he may seek compensation from the landlord for the loss that they've sustained. So there's always an element of risk, but again, it comes down to whether the items are of any value or not. And that comes down to as well a commercial view that the landlord takes. Whilst it would be open to you to assert that the goods have been abandoned, the fact that the tenant has returned to collect the items will make it difficult to raise this argument. Nevertheless, as I say, you may take a commercial view and decide that the need to keep the communal area clear for fire and safety reasons outweighs the cost of compensating the tenant. This will need to be determined on a case-by-case basis with regard to what goods have been left. It goes without saying that the more valuable the goods are, the greater the risk to the landlord that the tenant will return and bring a claim. However, if you decide to go down this route, make sure that you do have photographic evidence of the goods that are being disposed of in order to avoid any arguments arising later. The alternative option is that you take steps to sell the goods if they are of value. If you decide to sell the goods, you will need to notify the tenant of your intention to sell them. So that would be that would prepare and serve an intention to sell notice pursuant to section 12.3 and part 2 of schedule 1 of the Torts Interference with Goods Act 1977. So again, I thought we'd have a look at the section itself in the Act, and it states again that the notice must specify the name and address of the bailee, i.e. the landlord, must give sufficient particulars of goods, give the address or place where the goods are being held, again if they're held in storage or they're in the communal area, they're still in there, specify a date on or after which the landlord proposes to sell the goods. Now, you may also wish to include the following information in that notice, being that when and where the sale will take place, that any sale or storage costs will be retained from the proceeds of sale. Please note though that unless the terms of the tenancy agreement allow for the cost of storage to be deducted from the proceeds of sale, this may be subject to challenge. Now, the period between the giving of this notice and the proposed date of sale must be long enough to give the tenant a reasonable opportunity to take delivery of the goods. There exists no guidance as to what is reasonable. The terms of the tenancy agreement or any policy that you've got may specify the length of the notice you must give. And if this is the case, it would seem to set the parameters of what is reasonable. In the absence of that, then in the absence of any express term or anything in your policy, then we'd recommend a starting point is 28 days. This being the minimum period of a notice to quit. However, less time may be given if goods are few in number, or more time may be required if the tenant is vulnerable or suffers from a form of disability. So we'd serve the intention to sell notice. Now that notice must be, as it says in 6.4, the notice must be in writing and must be sent by post in a registered letter or by recorded delivery service. Now, the notice will be deemed served even if it's returned due to it not being signed for. However, by way of a belt and braces approach, it is recommended that you always look to send the notice by first class post as well. That way, practically speaking, the tenant has a greater opportunity of receiving that notice, even if it's not signed for. There may be some circumstances in which it may be convenient to combine the collection of goods notice and the intention to sell notice by providing all the required details in one notice. Where this is done, it's essential that we send that notice by recorded delivery. So once we look to sell, we can either sell the goods or we apply for an order of sale to sell the goods. So the next step will be, as I say, physically selling those goods. When we're doing so, consideration must be given to adapting the best method of sale reasonably available in the circumstances. For the most part, this will require you to place the goods in an open auction. This will ensure that you have received the best possible price for the goods on that given day. If you decide to sell at an undervalue by selling or donating to a charity, you'll have to account to the tenant for the shortfall if the tenant raises any objection to this. The alternative would be to apply for an order of sale and then sell the goods. If the goods are particularly valuable or you're unsure that the goods belong to a tenant, you may wish to make an application to the court for an order authorising the sale of goods. This can be achieved through a standalone claim. As part of the order, the court may specify certain terms and conditions that have to be adhered to, such as the method of sale. The advantage of taking this additional step is that any decision of the court authorising a sale shall, subject to the right of appeal by the bailor, being the tenant, be conclusive as against the bailee entitlement to sell the goods. So this means that there can be no possible comeback to yourself in the event that the tenant or any other third party returns to claim the goods. It also gives good title to the purchaser as against the tenant, which may be needed to sell the belongings. Given the likely cost of making such a claim, this step is usually reserved for the goods that are of high value, for example, jewellery or motor vehicles. I've just made a note on the slides that we need to account to the tenant for the proceeds of sale. So having sold the goods, you must then notify the tenant that you've exercised your power of sale. This does not need to take the shape of a formal notice and merely just a formal letter in writing to the tenant will suffice in this regard. When accounting to the tenant, you're able to deduct from the proceeds the cost of the sale. You may be able to recover any storage costs incurred, particularly if the items of the tenant particularly if the terms of the tenancy agreement provide for this. So have a look at that. Even if the method of disposal was by putting the items in a skip or donating to a charity, you may wish to carry out the same steps as to make the tenant aware of the actions that you've taken to let them know that they've been disposed of. Now, in terms of the proceeds of sale, you need to retain the monies for a minimum period of 6 years. After 6 years, the tenant would lose the right to claim against you because they've only got a limitation period of 6 years. At this point, you'll be able to keep the proceeds of sale for yourself. So, moving on, when we come to an untraceable tenant, now there may be circumstances where the tenant hasn't provided a forwarding address or you're unable to locate the actual owner of the goods. Now, this can make it difficult to comply with the notices that we need to serve. But under the Torts of Interference with Goods Act itself, it does make concessions in relation to these circumstances. In particular, you would be relieved from your obligations regarding the service of notices as long as you are satisfied that the goods belong to the tenant and that reasonable steps have been taken to trace or communicate with the tenant with a view to serving the notices. As to what reasonable steps are, much will depend upon the individual circumstances of the case. However, a bare minimum, the effort should be made to speak to the neighbours and exhaust any or all contact details contained within the housing file for the tenant's relatives and next of kin. In any event, you would be well advised to send the notices to the last known address of the tenant, which may simply be the address of the tenanted property, in order to avoid any arguments at a later stage. Where the goods are collected, if the tenant does return to collect the goods or the items, you should verify that the person's identity, whether that be the tenant or the third party, and seek written confirmation that they are the true owner of the goods. Efforts should be made to obtain a signed receipt from the tenant, and an opportunity should be afforded to the tenant to inspect the goods in front of yourself, and for confirmation to be given that the goods are in the same condition as they were when they were left. If a third party claims the items, they should be asked to provide evidence of their ownership before releasing the items. If a third party claims the items on behalf of a tenant, you should check that they have authority and obtain written evidence of this before releasing the goods to them. Now, I just wanted to touch upon a case really. and it's the case that's on the screen, the Darocha Avuru um, Mortgage Express Limited, 2014. This is a prime example of a case where a mortgagee was in possession, was held not to be liable for damages, where the notice was given to collect the goods, whilst providing numerous warnings before the goods were disposed of, so they were not liable for any damages, because sufficient notice had been provided and numerous warnings given before they were disposed of. So, um, I appreciate that's a lot of information that we've gone through this morning as to what steps should be taken. So, in summary, um, there reasonable steps should be taken to investigate the owner of the items. It's crucial that we prepare an inventory and we take photographs of those items to avoid any later arguments by the tenant or the true owner that various items were present that are no longer there, um, and they try to seek the value of them. As long as we've got a detailed inventory and photographs to help establish our position, that would be highly recommended. Then we look at serving the notice in accordance with the Torts of Interference with Goods Act, making sure that you serve the collection of goods notice, allow that time for the tenant to come and collect those goods. If following that, we then consider whether we either dispose of them items or we then arrange to sell those items if they are of value. If they are of value and we're looking to sell those items, then we'd look at serving the notice, the intention to sell notice, and we'd serve that again on the tenant, giving them ideally 28 days as a minimum, depending on the terms of the tenancy and your policies that are in place. As I say, once that's done, we'd then obviously sell those items. Ideally, we'd do it in an open auction so that we get the best possible amount for them goods. Then once we've done that, we'd obviously need to then consider keeping hold of those proceeds of sale. Lastly, just some practical advice. It's acknowledged that the above procedure that I've talked about today can be time consuming. However, it's essential that we and recommended that we do go through that in order to protect your position as landlord and make sure that it limits and minimises the risk of a potential claim and damages being sought. So it is advisable to provide the tenant with the information confirming what will happen if items are left in the communal area. Doing this may discourage them from leaving the items in the communal area in the first place. But ultimately, you will need to approach these situations on a risk management level. There will be situations where the cost of complying with a procedure will need to be measured against the risk of and the value attributable to a claim arising out of a failure to comply with your legal obligations. So claims by a tenant can be few and far between, but extreme caution should be exercised when disposing of goods or items without taking the appropriate steps. So it's just making sure that you follow that procedure, and that if it avoids then any potential claims being brought, and if claims are brought, we've got sufficient evidence in place. So that was just a whistle-stop tour, basically, on the notices, the requirement under the Torts of Interference with Goods Act. So I just want to say thank you everyone for your time today. If you have got any questions, then by all means, you can put them in the Q&A box, and I will get round to them I'll give you time to do that. I just want to let you know that the next webinar is on the 30th of April, and that is what to do when a warrant suspension application is received. Everyone will receive a link in the following follow-up email with the slides that can all get booked on. But I will just see if there is any questions. Just bear with me a second. Right. So Peter Grosset, can photographs be used instead of an inventory? Um, they can do. Ideally, when we're doing an inventory, I would make sure that if it is that there's a lot of items, you might want to sort of bulk the items together. So you might want to say if there's a large, I don't know, a large bunch of clothes left, then, or a bag of clothes, you might want to put black bag of clothes and take photographs. Ideally, we'd recommend both. But photographs are the key really, so that you establish as well if what the condition of that them items are, so it avoids any argument later down the line that items are there that weren't actually there, or there's been items damaged as well. So ideally I'd do both, but um if it is that you'd prefer to just do the photographs, then that would be sufficient. Apologies, it's the fire alarm that test that's just going off. Um, so ideally we just we do both, but if it is that we've got the photographs, that should be sufficient. Then we've got Gemma. If the item is in a cupboard, so not easily visible, does a copy of the tort need to be sent to every property within a block? What we'd usually recommend is, I mean, we'd usually put a copy of the tort notice on the cupboard. If it is that it's not easily visible by putting it in the cupboard, we'd put a copy on the cupboard. You might want to, once you make inquiries, it might minimise your search as to where you would then deliver the tort notice. It might be a particular, say it's a block of flats, it might be a particular level or floor that the actual items belong to, in which case you could potentially serve a copy of that tort notice, but ideally we'd put a copy on the door of the cupboard. It's difficult if it ends up being a property that items are left in. Say, for example, the tenants left and left I and abandoned the items. We wouldn't usually recommend putting the tort notice on the door of the property, purely because you're letting people know that it's empty and there's goods in there. But if it's merely just a cupboard in the communal area, I would put a copy of that tort notice on that cupboard door so it's visible and everyone can see. Zucker, hi. If our policy is to dispose of items and we don't sell, can we give to a charity without the need to do the order of sale? So yeah, we obviously if the items, you don't have to go down that order for sale. That would just be as a last resort protection for you. That would be usually if the items are of significant value, then we'd highly recommend that you go down the order for sale. So if they are quite valuable, the items, then we'd look at that route. If they are that they're not really, if they are that look consider it that it's not a value the items, then we can obviously look to dispose of them and not sell them. That is one option, and give them to charity. How long must a tort notice be for? So initially, the collection for goods notice, it will depend on, again, have a look at the tenancy, see if there's anything in there, and have a look at your policies and procedures, and make sure you're following them in terms of your time frame. Now, we'd usually say that for a tort notice initially, it needs to just be a reasonable time. As I said before, there is no guidance on what a reasonable time is. Therefore, we'd usually recommend giving 28 days and then another 28 days thereafter for the intention to sell. That should give sufficient time. There is case law that suggests that it needs to be a minimum of 3 months. But if you can establish that 28 days is sufficient and then 28 days, that should be enough. Then we've got Joanne. What could we do if a piece of furnishing in the communal area is being claimed as being purchased by a resident, but they are not providing evidence? So it comes a little bit sticky then. If you're if they are not providing you with evidence of receipts, then what I'd look at possibly doing is going down the route of intention to sell. If it is, we'd go through the tort notice for them to collect it. It becomes a little bit difficult. Make sure you're doing all your checks with all the other neighbours to see if it does point to that particular tenant that is claiming that they've purchased that the furnishings. But it's difficult if they're not providing evidence that they own it as the true owner. I'd probably see if they've got any sort of bank statements of them purchasing it, or if they can get a receipt, or that you can make inquiries with where they have purchased that. Obviously, that is time consuming. So initially, I'd make some inquiries with the other neighbours to see if that does point towards the resident may have left that and it's nobody else's, and nobody else is actually claiming it, then potentially it could be theirs. But if failing which, you'd look at doing the going through the tort notice procedure. Then Peter, are there any changes to this process for external? No, we'd recommend that takes effect on the outside as well. If there is things that's being left in the external communal areas, the same procedure applies. Again, make inquiries. Once you've made the inquiries and you can establish who the tenant is, then have a look at your tenancy agreement, your policies, see what they say about things being left, and then you do the collection for goods notice at that point. Then anonymous attendee. This is what our tenancy conditions say. You must cooperate with the council and your neighbours to keep any communal areas clean, tidy and clear of obstruction. You must not place any play equipment, shed or other structures in any communal gardens or grounds. Do you need to update this so it says we can remove after 24 hours notice? Items left are normally bikes, scooters or toys. Now, you may want to add something and just update your terms and conditions if you're wanting to minimize and reduce the time of notice for collection. You'd need to include that in there, just so that it just effectively, the reason why we'd include it in the tenancy agreement is to try and discourage tenants from leaving items in there. If items are left, then we just go through the usual collection of goods notice. But it is just up to you whether or not you want to update your tenancy agreement so that we try and discourage, it might discourage the tenants a bit more if they've got a time scale there, that if it's not removed by a certain time, it will be removed. And then Sue King, I have a lot of issues with push chairs being left in communal areas and items being stored in communal areas as an extension of the property. They don't have room in the flat. Ooh, now, ultimately, that's a difficult one because there's not really much that if the tenancy agreement says that things can't be left in the communal areas and items can't be stored, then they ultimately they can't leave their push chairs there and they need to effectively remove them. It may be that it's worth just having a conversation with them, and it may be that there might be some room somewhere for sort of a pushchair storage unit that's not necessarily dealing and essentially in the way of the communal area. It's not blocking the communal area, that might resolve, and it's working with that tenant. But ultimately, it can be difficult. It's worth just speaking with the tenants and just putting them on notice that they can't be leaving the pushchairs there in the communal area because it's for fire safety reasons. And then Natalie Bailey, can you hand deliver the letters if a communal block as well as post? Yeah, the more you can do, the better. Would this be good practice to show you've done all you can to contact the owner? Yeah, anything that you can do, as much anything you can do. I always say more is better. So if you can hand deliver the letters and post them, great. then we can show that they have been sufficiently served. So the more you can do, the better. Have there been any legal challenges to this slow process after Grenfell to help the reinforcement of fire safety regulations? Oh, that steps out a little bit outside my my remit because I don't deal with fire safety regulations. One of my colleagues deals with fire safety regulations, particularly for leasehold buildings. So it may be something that potentially you want to drop me an email after Peter Grosset. My email's on the slides, and I can give it to you again. It may be worth just dropping me an email, and certainly I can raise the question with my colleague who deals with leasehold queries in relation to fire safety regulations, and get back to you on that point. What if the items are blocking an exit route? Do we still have to issue a notice as fire compliance is compromised? If it is, this is when it may be ideal to put the items in storage. So we would remove the items, put them in storage. We'd then effectively serve that tort notice, do the collection of goods notice to say the items are being left in the exit route, and they can't be there. So it may be a case that for fire compliance reasons, it's worth just putting them in storage. At that point, Tracy Lease, we may have many issues with buggies being left in our communal area from residents and visitors, which is hard to keep track of. We leave a 7-day notice on the buggies, and I have placed notice on every floor of the building requesting no items be left in the communal area. The buggies in the communal areas create an ongoing fire risk issue. Yeah, again, I think I may have touched upon this above. If it is that we're leaving the notices and they're still not being removed, then it's going to be a case of going through the torts process, because ultimately you've given the opportunity to remove them from the communal areas, and if they don't do that, then it's going to be a case of considering commercial view. Is it commercially going to be beneficial just to dispose of those than the risk of a claim being brought for damages? But again, I would just go through that torts notice and procedure and put them on notice that, and have a check of your policy and your tenancy agreement to make sure that it's clear about buggies being left in the communal areas. Tracy Mandeville, we currently have a process where we keep people's belongings in storage for 28 days. Following an abandonment, they dispose of. Is this sufficient? What? Yeah. So once we've done if you've done the storage, when you're putting them into storage for 28 days, I'd make sure that alongside that you're doing your collection of goods notice. Once you've done your collection of goods notice, put that in line with your 28 days of storage. Once that's happened, obviously you either dispose of it or you look to sell it, depending on whether the item is of value. So yeah, that is sufficient. Just make sure you're doing your court's notice as well. Do you need to issue a retrospective? Sorry, this is Gemma Abley. Do you need to issue a retrospective tort for items that require removal immediately due to fire risk? Yeah, so I'd remove it for a fire risk and still do your tort notice. So if you're removing it for a fire risk and putting it in storage, still do your torts notice, and serve that on the tenant. Do you want to Kinsella? If no one else claims, can you gift it to the one who is claiming it's theirs, even without receipt? Yeah, I think if it is that no one else is claiming it, and ultimately you'd be once you've gone through your torts notice, no one's the collection of goods, no one's collected it, and then we look to either dispose of it or sell it. When you're looking at going down that route, then that's when you can dispose of it by donating it, and it may be that we donate it to that particular person just so that it's dealt with. Anonymous attendee, tenant will state, do you expect me to leave my baby attended and go and drag a heavy pram upstairs? Again, it may be that to try and, if we have got a constant problem with prams, it may be that potentially you have a look at would a pram store be feasible? I'm not saying it would, but would that be feasible to try and minimize and have it all labeled up that only prams would be be able to be left in the communal area in a particular station that would effectively not wouldn't interfere with any fire safety um, exits. So it may be that you might want to have a look internally at if there's some sort of compromise with that. Because if it's a repeat problem, what you don't want to be doing is it's just going to be costing you more resources, keep sending tort notices out. There may be a solution then. I'd have a look at that. Um, then we've got, can you provide a template of the tort notices, please? That's certainly something that I can have a look at sending. As I say, there is no set tort notice template as such, but I have got a couple that are a collection of goods and an intention to sell notice that we can use, and potentially I can speak afterwards. If you want to drop me an email, we can have a look at that. Um, so what if the pram is under the stairs and not blocking access? Well, if that's the case and it's not in a station, buggy station, shall we say, and it's even if it's not blocking the access and it shouldn't be left in the communal area, you go through your collection of goods and your torts notice procedure. Um, it's just a way around that rather than having to keep sending out tort notices. It may be that there's a pram station under the stairs. If it's not blocking access, that may be the solution there. But if not, if that's not the route that the landlord wants to go down, it will be ultimately following the procedure of serving notice, the collection of goods, and then intention to sell if it's not collected and removed. Okay, doesn't look like we've got, just stop sharing my screen. Can't see any more questions coming through. I hope I've answered everything for everyone, and that's been very helpful. I'll just give it a couple of minutes just in case anyone's got any additional questions. Right. Well, thank you everyone. Thank you for joining. Hopefully it was very helpful. Um, so as I say, you will get a copy of the slides and on a follow-up email, as well as a link to the next what to do when webinar. A copy of the recording will be on YouTube for you to access at any point following the webinar if you want to have a look at that again or refresh your memory. But thank you everyone. Thank you for